Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Slancha, my friends. Happy St. Paddy's Day. Happy St. Paddy's Day. Today is Tuesday, March 17th, 2026. And just when I was thinking, like, what was I going to cover today? I have a bunch of things on a list of things to cover. Then I got the breaking news that the order on the motion to disqualify Cosgrove and Aiden KEARNEY, a.k.a. Turtleboy's case, just dropped. So we're going to look at that in a moment. How's everyone doing? Happy St. Paddy's. I even have my green lighting behind me and this banner, this Turtleboy background is always green. So kind of fitting, right? Kearney's a nice Irish name. How many of my friends in the chat are Irish today? Or only on St. Paddy's Day? How's everyone doing? Happy Tuesday. I have a kid who just went to the parade in the city. I'm like, well, I don't know. Maybe the parade is over already. I'm like, yeah, be careful on the train home because it's like the drunk train. If you know, you know. It is the drunk train on St. Paddy's Day, and people are throwing up all over the place. And I got a lot of Irish in me too. And yeah, everybody's Irish every day. I love Irish. I love St. Patrick's Day. It's my favorite holiday. And I do like some corned beef and cabbage too. I don't know if I'm going to have it today, but I do like it. Let's take a look at our motivational daily calendar. And since we were not live yesterday, Monday, we'll look at Monday's motivational quote, and then we'll look at today's motivational quote. And sometimes they're very, very fitting for the things that we are covering. All right, so yesterday's quote from Monday, March 16th. It is a Russian proverb. Praise loudly, blame softly. If you needed to hear that today, I'm here for you. Praise loudly, blame softly. That is a Russian proverb. Just say something nice to somebody today. Make an effort to say something nice to 3 strangers. Compliment 3 strangers today. You never know that you could, or how, or what effect your compliment could have on someone who's having a really rough day. You could turn their whole day around, right? I think it's a great one. I love it. All right, today's St. Patrick's Day motivational quote reads as follows. Oh, look at this. This is so ironic because of what I just said. Kind words can be short and easy to speak, but their echoes are truly endless. Does anybody know who said that? Kind words can be short and easy to speak, but their echoes are truly endless. Mother Teresa. And there we go. That's a good one. 10 Curio 6679. Strangers are easy. It's not punching the people who piss me off that I struggle with on the daily. No, I hear you. I hear you. But let's try and have a good day. It's a good day to have a good day. So let's have a good day. What do you think? I mean, we can at least try. Thanks, Strange Credulity, for a gift and a membership. And Randalisa became a member. Welcome. And for those of you, Nicole says, my son Dominic's middle name is Guinness. His due date was St. Patrick's Day, and he came 3 weeks early. Oh, I love that for you and for him. And happy birthday, late, to your son Dominic. Nicole, thanks for your 5. I had a thought, and it just left me. What was I thinking? I don't know. But St. Patrick's Day is always a good time to watch this original Crichton Leprechaun news story from NBC 15 News. Do you guys know about this one? One of my kids sent me this, and it's amusing. So let's take a look. It's old too. I'm not sure how old exactly it is, but it's like one of those old viral YouTube videos from back in the day. All right. Are you ready for it? Here we go. The townspeople think they saw a leprechaun. This is real. I believe. Erin go bra. Kiss me out, Irish. You didn't miss anything, Kyle. Here we go.
Well, just in time for St. Patrick's Day, crowds are coming by the dozens to get an up-close view at what some say is a piece of Irish folklore.
Some people in the Crichton area of Mobile say a leprechaun has taken up residence in their neighborhood. A leprechaun. NBC 15's Brian Johnson has more.
Curiosity leads to large crowds in Mobile's Crichton community. Many of you bring binoculars, camcorders, even camera phones to take pictures.
To me, it look like a leprechaun to me. I gotta do is look up in the tree. Who else in the leprechaun say yeah?
Yeah.
Eyewitnesses say the leprechaun only comes out at night. If you shine a light in its direction, it suddenly disappears. This amateur sketch resembles what many of you say the leprechaun looks like. Others find it hard to believe.
If you didn't see the amateur sketch, you got to come back to your screen for just one moment. I'm trying to figure out when this is from. 2017. I want to say that I think it's older than that, but here's the amateur sketch of what the leprechaun looks like. Moving on. Sometimes we need to laugh or we're just going to cry all the time.
It resembles what many of you say the leprechaun looks like. Others find it hard to believe and have come up with their own theories and explanations for the image.
My theory is it's casting a shadow from the other limb.
Could be a crackhead that got hold to the wrong stuff. And it told him to get up in a tree and play a leprechaun.
We're going to get down to the bottom of this.
It could be crackhead.
Yeah, it's still on there, guys.
Got hold to the wrong stuff.
For the image.
My theory is it's casting a shadow from the other limb.
Could be a crackhead that got hold to the wrong stuff. And it told him to get up in a tree and play a leprechaun.
We're going to get down to the bottom of this. Yeah, it's still on there, guys. Don't be afraid. Don't be afraid, man.
This guy helping to direct traffic says he's prepared for his encounter with the leprechaun. He's
This guy.
suited up from head to toe.
This wars off smells right here. This is a special leprechaun flute, which has been passed down from thousands of years ago from my great-great-grandfather who was Irish. I just came to help out.
Others just came to get lucky in hopes a pot of gold may be buried under this tree.
I'm gonna run a backhoe and uproot that tree. I want to know where the gold at. I want the gold. Give me the gold. I want the gold.
This is Brian Johnson.
That's so classic. I want to know where the gold's at. Give me the gold. I want the gold. Hold on. We got to hit it again. Oops.
Lucky in hopes a pot of gold may be buried under this tree.
I'm gonna run a backhoe and uproot that tree. I want to know where the gold at. I want the gold. Give me the gold. I want the gold.
This is Brian Johnson, NBC 15 News.
People will do anything for a pot of gold. I mean, anything.
You know what I like? I like the amateur sketch of the leprechaun. It
Yeah,
looked like somebody
yeah.
got a really good look at it and got that good drawing out
Who
there.
did that? I want to know who sketched
I
that.
don't know. Maybe Brian sketched.
Doodling.
That was a good
So
story.
good. So good. It was from 2006. Thank you. Thank you very much for that. It's from 2006. It makes me laugh every time. Kind of like the there's a couple of them that are viral that I've just been watching for years. Like, ain't nobody got time for that. That is a funny one. There's fire. That's a funny one. And the one that they made into a song about the girls that were in the house. There's girls up in that house. I knew when a pretty little white girl run into a black man's arms, dead giveaway. That one, the dead giveaway one. And that guy, the dead giveaway guy, didn't they give him McDonald's for life? Didn't he mention McDonald's and then they gave him McDonald's for life? Hide your kids, hide your wife. Yep. Dead giveaway. The dead giveaway one. I love that. I love that. I watch it all the time. If you ever need something to laugh, make you laugh, that's a good one. Or otherwise, wait, that was the wrong one. Also, I can watch babies laughing all day long. The videos of the triplets laughing, the babies, I love it. Love it so much. I love it. All right. Free Turtleboy, says Anna. Well, Judge Belizos has issued his order on the motion to disqualify Special Prosecutor Robert Cosgrove. And not very long. It's 2.5 pages long. If you haven't seen it yet, let's take a look. This is going to be a cold read for me because literally I just got a full copy of it maybe 5 minutes before we went live. We've been waiting for this for a long time. The original motion was made, I don't know how many months ago. And it's been with a million judges. And I don't know that much about this judge, but let's take a look because you remember the argument, right? Aidan Kearney is facing, aka Turtleboy, a journalist from Massachusetts who has been covering cases for at least 10 years and writing stories for at least 10 years that he self-publishes on his own website. In my opinion, that doesn't make him any less than less of a journalist. That's someone who works for, a mainstream media station. Because look what just happened at Court TV. Everybody got fired. Every single person at Court TV got fired except for Ted Rollins, Vinnie Politan, and maybe one other person. And guess what they're all doing now? Oh, that's right. They're all coming to the real media, which is YouTube. So Aidan Kearney's been covering cases and exposing corruption in Massachusetts for 10 years prior to ever reporting on the Karen Read debacle. And Aidan Kearney is facing something like, I don't know how many felony charges are left, maybe 16, 17 felony charges for alleged witness intimidation, for asking the tough questions of witnesses in the Karen Read case. He was trying to get to the bottom of who murdered John O'Keefe because he, like many of you and I, did not believe that according to medicine, science, physics, and common sense, that John O'Keefe was hit and killed by a car, any car, not just not Karen Read's car, but any car. And so even after Karen Read's 2 trials, 1 mistrial, 1 acquittal, except for a last-minute add-on DUI charge for which Karen Read received 1 year's probation, Aidan Kearney is facing technically, we're going to do air quotes today because we are Gubitosi fans, not really. Technically, something like 90 years in prison for alleged witness intimidation for doing what old school journalists do or used to do anyway, like knock on doors, ask questions, put microphones in people's faces, put their, try to get to the bottom of the story, right? So Aidan Kearney is facing close to 100 years in prison. Tim Bradel, who also represents Kelsey Fitzsimmons, is representing Aidan Kearney, as you know, and our friend Mark Betterow is also on the defense team for Aidan Kearney. Both Mark Betterow and Tim Bradel are huge proponents of not only the Constitution, but specifically the First Amendment. And the First Amendment protects certain kinds of speech. unless they are perhaps true fighting words or true threats. And there may be some other exceptions to that. However, Aidan Kearney has been fighting this battle since his arrest. Well, since before his arrest. When were his indictments? 2023, October 2023. Then after that, they set him up. They did a bump. And they incarcerated him for what they told him was going to be 90 days. But it turned out under the statute, they could only incarcerate him for 60 days. And that was in the beginning of 2024. And then he got out of jail in something like February of 2024. And his case is still going on. It's going on for like 2.5 years. And the amount of money that he spent on attorney's fees and everything else, when this should be clearly protected speech under the First Amendment, is wild to me. But what had happened was, because Michael Morrissey was prosecuting Karen Reed, he had a conflict and he couldn't prosecute Aidan Kearney. And so they had to go outside the office and hire a special prosecutor. The first special prosecutor that they hired was a guy named Ken Mello. Ken Mello is among the missing. We haven't seen him in a long time. I need proof of life on Ken Mello, but unclear whether he's still on the case. I think he was actually disqualified from one case. And then Robert Cosgrove came out of retirement. See, he used to be a Norfolk County judge in Superior Court. Funny, right? And perhaps he's a friend of Michael Morrissey's, but he came out of retirement to help Ken Mello prosecute Aidan Kearney. And he remains right now the special prosecutor for Aidan Kearney. He's also now somehow magically, which is so fitting because we're talking about leprechauns and magically delicious. Cosgrove is now magically arguing to hold on to Karen Reed's phones that were seized in January of 2024, which the Commonwealth claims they've never searched, despite the fact that they did get a search warrant to seize the phone and download the phone, because I looked at the search warrant again the other day. But what had happened was, allegedly, apparently, according to them, they never did download Karen's phone. I don't know. Do you believe it? I don't know. I'm not sure. And I think it was Judge Doolin who last week we went over this order, told Karen Reed that she's entitled to get her phones back, but we're going to let the Commonwealth hold on to them until all appeals are exhausted. So all of a sudden, Cosgrove has now been specially appointed, apparently, to argue for Karen Reed's phones. So is he now also the special prosecutor to try and prosecute Karen Reed and Aidan Kearney for conspiring to commit witness intimidation against the Haas defendants and others? Unclear. But they really, they're like a dog. They're like Chloe with a bone on this. They just don't want to give up. And so what had happened was, Lindsay Gattani, when I told you about the bump before, was Aidan's girlfriend during a period of time. And then I guess they broke up. And then some people got their claws into Lindsay Gattani, and they used her. I call it a bump. Some people call it tickling the wire, but it's a trigger, basically. It's a trigger to get something you want. And they used Lindsay Gattani to get Aidan Kearney so they could make up some charges against him to violate his bail conditions and put him in jail for the 60 days, which they did, which they happily did. Here's the issue, okay? The tickling of the wire and or the bump, if you followed the Donna Adelson case, was Brian Tully serving Lindsay Gattani with an alleged grand jury subpoena to testify against Aidan in the witness intimidation cases involving the Haas defendants. Okay. It's right there. It's plain as day. It's on the subpoena. And so automatically, right, as a matter of law, that would mean in their minds that Lindsay Gattani had some information regarding the alleged witness intimidation of the Haas defendants and others. And so therefore, because in Aidan's trial, Cosgrove would have to call Lindsay as a witness and question her. And because Lindsay has sued Cosgrove and the Norfolk DA's office for violating her civil rights and other things. The defense position is that it is a conflict for Robert Cosgrove to continue to prosecute Aiden Kearney when he's a defendant in a case brought by Lindsay Gattani or third-partied in by Lindsay Gattani. And so he's going to have to, he's going to be conflicted because he's going to want to make her look like a reliable witness in his case against Aiden Kearney, but then he's going to want to not disparage her, but he's going to want to make her credibility look not so much in the case against him. Okay. Seems to me like a clear conflict. They've been fighting about this for a long time. And Judge Belizos has issued his order just today. It is docket number 132. Docket number 132 on the Commonwealth versus Aiden Kearney case. And here we go. I haven't read it yet, so I'm not even sure quite what it's going to say. I usually always look at the end to see, but we'll talk about it. I got to say I'm not surprised by it because at the last hearing, Belizos said to Cosgrove, he said, well, you know, Cosgrove argued that she's not a relevant witness. I'm not really going to need to call Lindsay Gattani. It doesn't really matter. I have immunity. The case is probably going to get dismissed against me anyway. And then Judge Belizos said, well, like if you do call her, do you think you could get another special prosecutor in to just question her? It's wild. We're in the upside down, inside out Narnia of Massachusetts. And this is Judge Belizos's order regarding the motion to disqualify Cosgrove, papers number 110 and 117 in the Aiden Kearney case. After careful consideration, the defendant's motion to disqualify Special Prosecutor Cosgrove is denied. Denied. Oh, let's use a green highlighter today. As basis, therefore, the court relies on the following. Yeah, I think he's going to go get somebody at the special prosecutor's store. First, the defendant's reliance on the United States v. Helt, 1981, is misplaced. Helt stands for the proposition that disqualification is required when a prosecutor's personal interest as the defendant in a civil case will be furthered by a successful criminal prosecution. The counterclaims brought by Gattani, he's going to twist himself into a pretzel here, I have a feeling. The counterclaims brought by Gattani against Special Prosecutor Cosgrove were part of her answer to a lawsuit filed by Kearney in Worcester Superior Court, alleging libel and slander against Gattani as a result of her statements/writings implicating Kearney in essays or alleged grape. Gattani's counterclaim against Special Prosecutor Cosgrove centers on his production of unredacted materials to Kearney's defense attorneys in the instant matter, which detailed/supported Gattani's allegations that she was the victim of multiple felonies perpetrated by Kearney. On February 12th of 2026, Kearney and Gattani filed a joint stipulation of dismissal, releasing each with prejudice from any claims brought in the Worcester matter. We went over that. That case was withdrawn. They filed a stipulation of discontinuance. That's what we would call it here anyway. Kearney now is eliminated as a party and in all probability as a witness in that case. Footnote 1. As he is no longer a party, Kearney cannot be forced to testify about his alleged essays or his alleged dissemination of protected materials in the event Special Prosecutor Cosgrove sought to call him as a witness in defending the Worcester counterclaims, thereby eliminating the possibility of using a potential Norfolk County conviction for impeachment. As such, the court concludes that there is no reasonable basis to believe that a successful prosecution against Kearney for witness intimidation against third parties in Norfolk County would assist the special prosecutor in defending against the counterclaims brought by Gattani in Worcester County. Footnote 2. Which reads, none of the remaining alleged victims in the Norfolk indictments are involved in the Worcester litigation. The essence of Gattani's counterclaims in the Worcester matter is that she was harmed by the acts of KEARNEY in allegedly disseminating directly or indirectly unredacted essay reports produced by Special Prosecutor Cosgrove while fulfilling what he will likely categorize as his Rule 14 obligations in the instant matter. Yeah, you know they're interesting when they make me buffer for a moment. I know. I'm trying to untwist the pretzel here. This is like a contortionist. You're confused. I'm confused. We're all confused. But couldn't the other side subpoena him just because the state won't meet? It's not. Yeah. And she's suing Tully Cosgrove and Michael Morrissey's office, right? Okay, moving on. As such, the crossover between the instant criminal matter and the Worcester civil litigation is minimal. It's minimal. I don't know. I really feel like I'm in the Twilight Zone now. My analysis is confused. My brain is confused. All right, let's just keep reading. Second, leaving aside the question of how Gattani might surmount the formidable immunity defense available to Special Prosecutor Cosgrove, her complaint is flawed, likely fatally, procedurally. See Rule 14. Further, even if her claims were properly lodged, no return of service has been filed with the Worcester County Superior Court, and the time for doing so has long passed. As such, her claims are effectively dead. Massachusetts Rule 14. Okay, typically, after you serve a complaint on a party, a summons and complaint here in New York, you would have to file your affidavit of service with the court, typically within 30 days. I'll look up Rule 4 to see what he's talking about, and he may be right there, but hold please. Thus, the Worcester counterclaims present no meaningful threat to the special prosecutor or his ability to be fair and impartial. Third, the Commonwealth has indicated that an alternative special prosecutor will be available to examine Gattani in the event that she is called as a witness. See paper 131 of the instant matter. Thus, any theoretical conflict which might arise if Special Prosecutor Cosgrove were to cross-examine Gattani in the Norfolk prosecution has been eliminated, because they can just bring in another person to examine Lindsay. It's not really the way it works with conflicts. They are really stretching. Here's the problem. All right, let me finish reading and then I'll tell you the problem. There's a lot of problems. Third, the Commonwealth has indicated, has been eliminated because they have an alternative special prosecutor, another friend of Morrissey, FOM, friend of Morrissey. Accordingly, given the court's application of HELT, the irregularities / flaws in the Worcester matter and the remedial measures taken by the Commonwealth and the special prosecutor, Cosgrove, the circumstances before the court cannot survive the close scrutiny required before taking the very substantial and exceedingly rare step of disqualifying counsel. Citing a 2012 case from Massachusetts dated yesterday, XOXO, Christopher Belizos, Justice of the Superior Court. court. This is a lot of twisting. Here's the problem. Okay? If Cosgrove is disqualified, Michael Morrissey has a conflict. His office cannot prosecute Aiden Carney. It would have to go to a different district attorney or I don't know, potentially the feds. Do you remember when we uncovered some emails in a FOIA dump from Morrissey to the feds begging them to charge Aiden Carney with something? Am I misremembering? It's possible because the FOIA dumps were huge, but I do remember some emails pleading from Michael Morrissey pleading for the U.S. Attorney's Office to charge him, right? I can't believe that's right. Jen McAlbert can't recall says, I can't believe they're charging him, but not Justin. It for the money. Alien. Well, it's a different county. That's Essex. And so technically, Michael Morrissey wouldn't even be able to pick another special prosecutor. It would have to go to a different county. It was begging the AG, right? Oh, Magnolia Gypsy, did you notice the color of your new cupcake? I was able to make a new cupcake for all of the members who have been here for 2 years or more. So that's your new cupcake. Magnolia Gypsy is one of the couple of the few who have been here for over 2 years as a member. It's blue on the bottom. It's pink on the top and has a 2 on it, but you can't really see the 2 because it's tiny. Also a new tiny Jesus emoji for members because there are times when we need tiny Jesus. The only thing exceedingly rare, says Tortoise, is justice in Massachusetts. No other county wants to touch this. They don't want to touch it. And so that's a problem. Yeah, see the emoji? Oh, you can kind of tell what it is, right? It's kind of this one. This one has the pink little sash that says Jesus loves you. Questions. Does the conflict resolve itself because Aiden Carney and Lindsay Gattani discontinued Aiden's lawsuit against Lindsay? It's one question I have. If there was a conflict, is it now over because that lawsuit doesn't exist? A conflict is a conflict is a conflict. And my other question is, if Aiden discontinues his lawsuit against Lindsay or they sign mutual releases, let's say there was a settlement or an agreement or whatever, do Lindsay's third-party claims survive? Or would she have to file another lawsuit? Is the statute of limitations expired? I have so many questions. Right? No, we're not mocking religion, Autodoc. We're praying is what we're doing. We're praying for some justice. That's all. We are not mocking any religion at all. Although somebody did write me an email, you know who you are, to tell me that my spelling of St. Paddy's Day, Paddy, which is like short for Padraig, which is the Gaelic Irish version of St. Patrick, was a racial slur. Can my Irish friends just chime in on that? Paddy, that's the way we grew up spelling it. I don't believe it's a racial slur. Melanie, can you explain how he's able to take care of Reed's phone when he has nothing to do with their cases? Well, I'm glad you asked. Patty is the way to say it. Thank you. I've got Cosgrove's contracts. I've got his billing records. And why would he want to quit this case? He's making a lot of money. Right? That's right. Tiny Jesus rested on my cap, my Microdots hat, when Kelsey got her wins in court the other day. That's right. Everyone, don't forget to smash the like button. Also, YouTube algorithms have changed recently. A lot of people are complaining. A lot of creators are complaining about it. And YouTube is trying to push shorts on you instead of long form videos like this. So what I would ask that you do is take a moment. if you're on your phone, close out your chat. Make sure you're subscribed to this channel still. And there is also a way to change your homepage. You might have to do it from a laptop so that you can see less shorts. And the reason that they're doing that is because YouTube pays like a penny per view of shorts, and they make a lot more money if people are only watching shorts. And you guys, we're in my 80% of my audience is 45 and up. And also, a lot of you say that you're not getting notifications. You need to make sure you still have them set, because here's the thing. Out of 130 plus subscribers, only, let me give you the stats on this, only 20% of you have notifications set at all, which may be why you're not getting them. So you got to check that setting as well. And of those 20% who have notifications set, something like only 12% of you have it set to all notifications. So that's the thing. So there's 16,000 of you that have it set to all notifications, but you might want to just double check your settings and see if you can do that. And Jill says, all you need to do is click the three dots at the end of the shorts, opt for less shorts. Right. I don't do shorts either. Okay. Stacy Q. Melanie, update. Our motion to dismiss hearing has been moved to May 14th at 9 a.m. in Suffolk Superior Court. The reason is because of a potential time conflict with my lawyer. Stacy, I don't think that I'm following your case. Or are you talking about Aiden's case? Are you using Aiden's third-party voice? Otherwise, I'm super confused. Are you talking about the mega motion to dismiss? Thank you, Thunder Snow Doggy Paws. I can't set them for you. I wish I could, Coco. Coco's the one who made the tiny Jesus emoji. Thank you, Coco, for making the tiny Jesus emoji for us. Thank you very much. Thank you very much. Hold, please. Maybe. I mean, maybe. Judge Belizos has reviewed the mega motion to dismiss. He's looked at all the hyperlinks. Maybe he has intellectual curiosity, like Kelsey Fitzsimmons' new judge does. Remember, he told us he had intellectual curiosity. He actually said that twice, Judge Karp, and he read the entire file, and he knew everything about the case by the last hearing, which we covered, I think, on Thursday. Oh, Turtleboy just tweeted that. Okay. Okay. And I think I know why, because Kelsey's trial that Tim Bradle is also on is going to be on the same day as the motion to dismiss, which was supposed to be next Friday, I think, the 27th. Right. Okay, so they've adjourned it ahead of time because Bradle is busy in trial prep. So thanks, Coco, for the emoji. I prefer this style too. Thank you, Stacey Q. I'm like, Stacey, am I covering your case and I don't know it? Marion says, wasn't it Tully and Cosgrove that made the claim against Turtleboy on behalf of Lindsay Gattani? And she said it wasn't her. So why is this judge saying this out loud? She said that she didn't want to press. I don't know. That question is confusing me. Okay, Turtleboy tweeted that. All right. We're clear. We're clear now. Let's take a look again, because this is what we need to do. We need to take a look at Lindsay Gattani's answer to the original complaint of Aiden Kearney. And this is in what county was it? Worcester. Hold on one second. I have a new system, so none of my documents transferred over. Let's take a look. Wait, did you see shorts of mine where someone poached my content, Little Cupcake? I know there's a fake person on on TikTok with my contact, but I wasn't aware of any shorts. If you see any shorts like that, let me know. Yeah, Turtleboy did sue Gattani, so just hang on for a second. We've been over that. It's in the playlist of all the Aiden Carney videos, which is in the playlist section, because I don't think I got a chance to link it down here, because what had happened was this is a last minute add-on. So hold, please. Let's take a look. I know, I love the babies laughing videos. All right. All right, well, this is kind of weird because there's a motion hearing in this case at 2 p.m. today. Is anybody going to that, or was it canceled? That's what it says on the docket. Look. Oh, please. Stipulation of dismissal with prejudice was filed on February 12th. We covered that. Applies to only Aiden and Lindsay. There's a motion to dismiss Lindsay's counterclaims. Hold on. Who filed that? Well, we didn't know about this. This is Haldeman. Hold on. All right. We're going to be here longer than we thought. So just hang tight, everyone. I don't know how this flew under the radar. Did anybody know about this? Detective Haldeman's motion to dismiss the counterclaims? Let's take a look at Lindsay's answer for a second. There's been a lot of other things happening in this case that nobody knew about, I guess. All right, so the complaint was filed by Aiden January 8th, 2025. Lindsay made a motion to dismiss based on anti-SLAPP. I think that was denied. Yep, that was denied August of 2025. And then Lindsay filed her counterclaim. Let's take a look. Lindsay's, it's 87 pages long. All right, we're just going to look at this briefly because of course it is. Because we need to refresh our recollection because it's been a while since we've looked at this case. And Lindsay filed this all the way back in September 2025. But this motion to disqualify prosecutor Cosgrove is denied because of some very creative writing. What are you talking about? Guilty on all counts for Corey Richens? Yeah. Okay. Moving in. Let's look at Lindsay's counterclaim. What a surprise. Let's not talk about my children in chat. Okay. Thank you so much. Appreciate it. A lot of crazy people on the internet. Okay. Here we go. Happy birthday, S. Hurt Locker. Happy birthday. Today, S. Hurt Locker is 65 and received his or her Medicare card. I want to wish Cupcakes a happy St. Patty's Day and may God bless Melanie. Oh, happy birthday. Thank you so much for your 20. And here's Fairy Raven. She's here from Ireland. She said it's always St. Patty's Day, DDYS, never PATTYS, from Derry in the north of Ireland. Thank you, Fairy Raven. Raven, it's not a slur, right? It's not a racial slur. Thank you for backing me up on that. All right. This is a civil action brought by Aidan Kearney against Lindsay Gattani, and this is defendants Lindsay Gattani's answer and counterclaim. Defendant counterclaim plaintiff Lindsay Gattani, pursuant to Massachusetts civil rules, hereby answers the complaint of plaintiff Aidan Kearney. This is a civil action. Aidan Kearney, and asserts counterclaims against Kearney and additional counter defendants, Medfield Police Detective Dylan Haldeman, MSP Lieutenant Brian Tully, Norfolk District Attorney's Office Special Prosecutor Robert Cosgrove, and Jason Broyles. And here we go. Let's look at that's her answer to Aidan's complaint. And so let's look at her causes of action against the counterclaim defendants. And these are people that she intended to implead into this action, but it seems to Judge Belizos that she may have done it improperly, and that because of that, it may be a fatal error. All right, let's say Broyles is a resident of Connecticut. And these are jurisdictional things. I have to redact some things. Here's the facts. She says on October 14th, 2023, Kearney essayed Gattani, began at McMorgan's Bar in Norwood, non-consensual contact in a public area. Oh, oops. But these two have discontinued their claims against each other. So let's see where she gets into Tully. Okay, here it is. On December 14th of 2023, during an interview with Lieutenant Brian Tully and a private investigator, Nelson D. Gouveia, regarding Gattani's knowledge of Kearney and another matter. Right. That other matter was the witness intimidation charges for the alleged victims of Jen McCabe, Matt McCabe, Proctor, Buchanan, the Alberts. So during that interview with Tully and that private investigator, Gattani first reported the assault. Tully urged her to file an official report, but Gattani declined out of fear of retaliation. She also claims she didn't want to report it. I think she since has said she didn't want to report it. On December 22nd of 2023, Lieutenant Tully and the investigator served Gattani with a grand jury subpoena unannounced. Right, and that grand jury subpoena was for the exact charges that Aidan is still going to stand trial about. Footnote 7 says see Exhibit D. Let's look at Exhibit D. Because this is the grand jury subpoena that they served her with. So I can have the receipt to show you that it was for that particular case. I mean, it's going to be kind of hard for it's going to be hard for them to walk that back when clearly the subpoena says what the subpoena says. Hold please 1 second. So just let me redact something. All right. Here is the grand jury subpoena that Tully served upon Lindsay Gattani on that date. This purports to be a subpoena for the Commonwealth of Massachusetts served on Lindsay Gattani. And it says right here, you are hereby commanded to appear. You're hereby commanded in the name of the Commonwealth of Massachusetts to appear before the grand jury for the County of Norfolk, 649 High Street, second floor, Dedham, on December 27th, 2023 at 9 a.m. and from day to day thereafter until the action hereinafter named is heard by said court to give evidence of what you know relating to the case of in re the investigation into Canton witness intimidation. That's exactly what it was for. That's exactly what it was for. We have seen in one of the mega motions or one of the million filings in this case that we have been over together that the grand jury was told on the date before December 27th, oh, you may have to come back on December 27th for another day. And so this is supposed to be allegedly a legit grand jury subpoena for specifically that particular case. I don't know if it's fake. I don't know if it's real. That remains to be seen. But wasn't the subpoena aroused to get Aiden to her apartment so they could arrest him right before Christmas? That's what I'm talking about, the bump. The bump. Knowing how he was going to react to this when she inevitably called him would get them in the same location, in my opinion, and perhaps bump him into doing something that they could use to then revoke his bail conditions. That's what happened. I don't know if this was real. I don't know if they really intended to have a grand jury, the grand jury that was already investigating this, because I thought they already had concluded and the grand jury on any other cases had not started yet. They had not been convened. And so this is what I am calling a bump. Let me know if you agree that this could potentially be a bump, a trigger, a way to have him violate his bail conditions so that they could make up some bogus thing that he did when he got into the same location as Lindsay and say that he pushed her onto the couch and he violated his bail condition. And she has said since then, he never pushed her on the couch. They said that. And so I don't know. But this is how it gets fugazi. It gets fugazi. Because here it is. Tully subpoenaed her to testify at a grand jury in that case. Cosgrove doesn't now get to come in and say, well, you know, we wouldn't really need her to testify in his case. But you did when you subpoenaed her to come and testify in front of a grand jury. That never happened. Okay. It also says that it's signed by the witness, Michael Ricciuti, at Dedham on December 22nd, 2023. I wonder what he's got to say about it. And it's got a stamped signature of Michael Marcy. And this is what they gave her. All right. So that is Exhibit B. On December 22nd, 2023, Lieutenant Tully and the investigator served Gattani with a grand jury subpoena unannounced. It's coming back to me now. When Lindsay went there, because she has been speaking out a lot, and I haven't watched it all, so I'm not really sure what she said. But when Lindsay went to meet with them on December 14th of 2023, there were text messages between Lindsay and Kate Peter, and didn't they look at her phone or something, and they found something in her phone, and they tried to convince her that it was an essay and that she should report, right, and that she should prosecute. Scott McGinnis is here. I know he knows all the details about everything. She had a lot of stuff in her phone. That's the way I kind of remember it. Yes. Amber says yes. She didn't want to do anything about it. She didn't think it was an essay, but that's what they did. All right. I mean, maybe one of these days the truth will Tully called the cops for yes. Okay. Moving on. On December 22nd, 2023, Kearney was invited to Gattani's home after Gattani received that grand jury subpoena related to Kearney and Karen Reed. Kearney declined that invitation. During that day and into the morning of December 23rd, 2023, Kearney began a series of harassing communications towards Gattani. Kearney sent Gattani highly sensitive judicial documents and made other implied threats until Gattani provided information to Kearney. He said he would visit her the next day, asked her to install Signal. We've been over this whole thing before, and it's 87 pages. On December 24th, 2023, Gattani reported assault and battery and witness intimidation to Lieutenant Brian Tully. Tully then called Medfield Police. Medfield Police then called Gattani and informed her they would be visiting her apartment. At that point, the Medfield Police took a police report. A BOLO was issued for Kearney, and an emergency restraining order was sought by Gattani and granted on Gattani's behalf against Kearney. But here, it even says right here, she thought, according to this document, this complaint, she thought she was served with a grand jury subpoena related to Kearney and Karen Reed. But we know that it wasn't. It was against the Haas defendants. A BOLO was issued for Kearney, and an emergency restraining order was sought by Gattani and granted on Gattani's behalf against Kearney. So yeah, he did not have a restraining order on her at that time. Somebody asked about that earlier. On December 26, 2023, Kearney turned himself in and was sentenced to 90 days in jail due to a sustained finding of Kearney violating his existing bail conditions on the December 2023 felony charges. On January 8th of 2024, the original restraining order was extended for a further term of 1 year. Gattani testified before the grand jury on February 1st and February 22nd of 2024. But wasn't that a different grand jury? Refresh my recollection. Refresh my recollection on what that grand jury was. That the Karen and Aiden grand jury that they did not indict the ham sandwich? Yes, the civil stuff between him and Lindsay has all been dropped, but the counterclaims of Lindsay against other defendants is the reason why Judge Belizos has declined to take Cosgrove off the case. And so that's why we have to go back and look at this. But yes, you are correct. She has not discontinued. Lindsay has not discontinued her claims against Haldeman, Tully, and the DA's office. Aiden's got a show tonight. He can explain this to you better than I can because nobody knows the facts of his own case at his fingertips than I do. So watch that tonight at 9 p.m. On February 23rd of 2024, Kearney was released after 60 days instead of his initial 90-day term due to statutory limitations and indicted for witness intimidation and illegal interception of oral communications. Okay, so that was for the wiretapping. In February 2024, Kearney violated the restraining order and was charged accordingly. Around February 28th of 2024, Gattani was summoned to Medfield Police regarding a false accusation by Kearney that Gattani wiretapped him by recording relations without consent via home security cameras. During the interview, police demanded to view all intimate videos and photos on her phone of Gattani and Kearney, which she provided under duress. In explaining examples of Kearney's own secret recordings, Gattani described this assault in October, along with 2 other occasions on which he had recorded her during an act. She then described the events of the night of October 14th, 2023 to the Medfield police officers. At that point, police paused the interview and informed Gitani that what she had just described was an SA. I was a little ahead of myself, but yeah, there it is. That was during her meeting with Medfield police in February of 2024. Gitani begged them not to pursue charges at that time due to fear of retaliation, including Kearney's threats to release videos. Gitani was never charged with wiretapping. Then she gets into Jason Broyles. Using the alias Haley Walbrecht, posted Lindsay Gitani's unredacted confidential police report of her assault allegations online. It was a multi-part blog series created by Broyles for the purpose of targeting Gitani on behalf of Kearney. And she says, the post was explicit and graphic in nature and contained lies about Gitani, mischaracterized the events, and falsely claimed police had concluded no rape had occurred. This was the first time Gitani had been exposed to the details of her own rape report. And that because of the things that Broyles posted, there was large-scale harassment against her. Causing emotional distress, further reputational damage. And there's a lot of salacious allegations in here, which you can go back. I'll put the original show in which we went over this whole 87-page complaint linked in the show notes later, because this is very long, very detailed, and she filed it pro se, but whoever wrote this did a decent job. All right, so let's get to the claims against Cosgrove. All right. Negligent infliction of emotional distress against all the counter defendants. The counter defendants, specifically Tully, Haldeman, and Cosgrove, owed Gitani a duty of care to protect her confidentiality and well-being as an SA victim under common law and Massachusetts General Law 97D and other statutes. YouTube doesn't like some of these words, so I just have to blur them out. They breached this duty through negligent release of the report, failure to redact, ignoring harassment reports, and improper handling of sensitive information. This breach proximately caused Gitani severe emotional distress with objective symptoms. As a direct result, Gitani incurred medical expenses, pain and suffering, reputational damage, and legal expenses. So here's one question. If Lindsay dismissed her claims against Aidan Kearney, does this claim for a negligent infliction of emotional distress survive against Cosgrove, specifically for purposes of this motion only and his disqualification? I would submit to you that it would, if it was filed correctly. And there may be some curative ways to do that if she never filed proof of service. But does Cosgrove, Haldeman, and Tully owe Gattani a duty of care to protect her confidentiality and well-being as an SA victim under the common law and Massachusetts law? Yes, they do. And if they release that unredacted report and she can prove it, she can prove that she sustained damages as a result of that. In my opinion. She also has a claim against this Jason Broyles for breaching his duty through negligent or reckless acts. But for purposes of this discussion and disqualifying Cosgrove, we don't need to get into that right now. Libel and slander against Kearney and Broyles. Invasion of privacy against all defendants. And this is interesting because I want to talk to you about Afro Man in a little while after this, because there's a trial going on right now that I think is very interesting that maybe we should cover. Count 7 is invasion of privacy against all counter defendants. The counter defendants invaded Gattani's privacy by disclosing private facts about her SA. For example, the unredacted reports details to Kearney without consent, portraying her in a false light and intruding upon her seclusion, leaks against her wishes. These acts were unreasonable, highly offensive, and violated confidentiality laws. As a direct result, Gattani incurred medical expenses, pain and suffering, reputational damages, and legal expenses. The counter defendants invaded Gattani's privacy by disclosing private facts about her SA, portraying her in a false life, intruding upon her seclusion, violated confidentiality laws, and as a result, she sustained damages. Count 8 is abusive process against Cosgrove and Haldeman. These are the two municipal defendants, but Cosgrove is specifically named here, so let's focus on him. Kearney, Cosgrove, and Haldeman initiated or facilitated legal processes. For example, discovery release, wiretapping complaint with ulterior motives, intimidation, enabling public disclosure, and without proper cause or safeguards. I mean, that is potentially a cause of action against Cosgrove that could be sustained. Maybe he's entitled to immunity, maybe not. But I don't think it gets you out of a conflict of interest to say it's probably going to be dismissed on immunity grounds. She didn't file her affidavit of service, and therefore Cosgrove doesn't have a conflict. That seems to me to be a great stretch. And then she's also alleging violations of the Massachusetts Civil Rights Act against Haldeman, Tully, and Cosgrove, saying that they acted under color of law, interfered with Gattani's rights under the Massachusetts Declaration of Rights by threats, intimidation, or coercion, including improper disclosure of confidential information and failure to protect from harassment. And she's asking for damages from all of them, including Cosgrove. Breach of statutory duty and negligence per se against Cosgrove, also, all the defendants, by failing to maintain the confidentiality of the SA report, causing her damages. Let's see. What else is against Cosgrove? She's also alleging, well, contribution, but that doesn't matter anymore because they've discontinued their case against each other. You know what we always say about negligence cases, right? This is a civil case. Duty, breach, causation, damages. Did Cosgrove owe Lindsay Gattani a duty to keep her SA report confidential? If that is true, if he does owe her a duty and he breached that duty, and she can prove that she sustained damages or emotional distress because of it, and that was the cause, duty, breach, causation, damages, she's got a case against Cosgrove. So I don't see how this judge, let's go back to the order now, can just say, well, no big whoop, because that case may be dismissed and we don't really need him, right? And her phone extraction. Oh, thank you so much. Thank you so much. You covered this on your live on 9th of September, 2025. You said then it wasn't properly filed. So unless there's been a separate claim filed, I think the judge is right here. Yeah, I said I didn't think it was done procedurally correctly, that they should have been third-partied in. But again, I'm in New York. That's the way I would do it here. He is saying what he is saying, what the judge is saying, the reason he is giving for it being procedurally incorrect is not failure to implead them as third parties, but because she didn't file an affidavit of service. That's what I read it to believe. But let's go back to it now. Sometimes we got to work. It's like showing your work on a math problem. You got to go back and show your work, especially when you're doing it on the fly. So let's go back now to the original order that we just read that dropped today. It's a good time to remind everybody, please hit the like button because it helps the algorithm. If you're just joining, let's read this one more time because it's short. This is the order on the motion to disqualify Cosgrove that was issued today or filed today. It was signed yesterday by Judge Belizos in the Aiden Timothy Kearney case. After careful consideration, the defendant's motion to disqualify Special Prosecutor Cosgrove is denied. As basis, therefore, the court relies on the following. First, the defendant's reliance on U.S. v. Helt is misplaced. Helt stands for the proposition that disqualification is required when a prosecutor's personal interests as the defendant in a civil case will be furthered by a successful criminal prosecution. Okay. He is a defendant in a civil case that has been discontinued. Lindsay counterclaimed against Cosgrove. Okay. We just read it. Belizos then goes on to say the counterclaims brought by Gattani and Special Prosecutor Cosgrove were part of her answer to a lawsuit filed by Kearney in Worcester Superior Court alleging libel and slander against Gattani as a result of her statements and writings implicating Kearney in essays. Gattani's counterclaim against Cosgrove centers on his production of unredacted materials to Kearney's defense attorneys, right? The essay report. And did it also include the phone extraction? Because we skipped through it. It was 87 pages. Which detailed / supported Gattani's allegations that she was the victim of multiple felonies perpetrated by Kearney. See paper number 8. And I think that's what we just looked at was paper number 8. On February 12th of 2026, Kearney and Gattani filed a joint stipulation of dismissal, releasing each with prejudice from any claims brought in the Worcester matter. That's true. Kearney is now eliminated as a party and in all probability as a witness in that case. In all probability, I don't know. Would she need to call him? She may need to call him. So I think that that's speculative, right? As such, as he is no longer a party, Kearney cannot be forced to testify about his alleged essays or his alleged dissemination of protected materials. In the event Special Prosecutor Cosgrove sought to call him as a witness in defending the Worcester counterclaims, thereby eliminating the possibility of using a potential Norfolk County conviction for impeachment. this is a lot of like speculative in the future type stuff. And I don't know that that absolves the conflict. I mean, I may be insane, but am I insane? Second, leaving aside the question of how Gattani might surmount the formidable immunity defense available to Special Prosecutor Cosgrove, well, I'm sure there are ways around it. So again, this is all hypothetical. Her complaint is flawed, likely fatally, procedurally. But he doesn't say why. But I did say this in the beginning that I think she should have third-partied them in as third-party defendants. I don't know the way that works in Massachusetts. Maybe this is the right way to do it. If there's any Massachusetts civil practitioners in the chat, feel free to tell me that you are, and feel free to tell me if third-partying in defendants in a civil case is not a thing, and this is the way you're supposed to do it. I might be wrong. Further, even if her claims were properly lodged, no return of service has been filed with the Worcester Superior Court, and the time for doing so has long passed. Okay, so he went into the docket to look at it to say she never filed the affidavit of service, I think. Let me just see. Let me just look up Massachusetts Rule 4. I mean, this is like we have to do all kinds of extra research to even figure out what this judge is even talking about. Civil Procedure 4. Rule 4. While the rule has been updated, it historically required service to be made within 90 days of the filing of the complaint to avoid dismissal. I mean, there may be a way for her to cure that if she didn't serve or file the affidavit of service within 90 days. It's a long rule. I'm going to have to read it in a little more detail before I can opine on that. I don't know. I don't know if it was Grant that helped her with it. I have no idea. As such, her claims are effectively dead. Well, I think Cosgrove admitted that he was served with it, so there's really not a question of service. Thus, the Worcester counterclaims present no meaningful threat to the special prosecutor or his ability to be fair and impartial. Yeah, that's just not the way it works. That's just not the way it works. Lexi, are you a lawyer? I think that's technically true, actually, under Rule 4. But the difference would be as if it were actually served versus whether the affidavit of service was filed or not. Well, we know Haldeman was served because he filed a motion to dismiss. Oh, here's Mary from Ireland chiming in. I love you all, but please no Paddy with a TTY. It is St. Patrick's Day or Paddy's Day with a DDY. From Mary in Kilkenny, Ireland. Sláinte, my friend Mary Walsh. Thank you very much for chiming in. I knew you guys would be here today. If Lindsay Gattani and her allegations are true, that Special Prosecutor Cosgrove caused her intentional infliction of emotional distress and violated her civil rights by releasing unredacted copies of her information and things that were supposed to be redacted, she has a potential cause of action against him. I don't know how that could not affect his ability to be fair and impartial if she's called as a witness. I don't know if she will be, but this is not, the law is not hypothetical, right? It's not hypothetical. Maybe this, maybe that. This could happen, that could happen. Therefore, I'm going to decide that Cosgrove shouldn't be disqualified. They know that if they disqualify him, they got to find someone else to prosecute him, and it might not happen. But maybe, like I was saying about intellectual curiosity, maybe the judge has read ahead in the docket and he's read the mega motion to dismiss, and he intends to dismiss the case. And that's why he doesn't want to get stuck in the mud here and disqualify Cosgrove if he's going to dismiss the case anyway, because it's not going to matter. I mean, that's like the tiny Jesus way of looking at it. You know, that's the, if you want to look at it in a positive light, that could be the reason, right? Because I don't see how this conflict is not a conflict. But again, third, the Commonwealth has indicated that an alternative special prosecutor will be available to examine Gattani in the event she's called as a witness. I don't know. That still does not waive the conflict to have another person come in just to question her. Because if Kelsey, if Lindsay's case survives and she still has a viable case against Cosgrove and others, or just for purposes of this conversation, Cosgrove, and if somehow she gets around immunity, he's going to try and discredit her in that lawsuit. But if he calls her in this lawsuit, he's going to want to bolster her credibility. Do you see? Thus, any theoretical conflict which might arise if Special Prosecutor Cosgrove were to cross-examine Gattani in the Norfolk prosecution has been eliminated. Accordingly, because the fact that she has sued him, okay, whether or not it gets dismissed, the very fact that she has sued him and he is a counterclaim defendant and or a third-party defendant in another lawsuit in another county, just the manner, just the very fact of that, in my opinion, is enough of a conflict. Is enough of a conflict for Cosgrove. And that's really the very narrow issue here. You know what I'm saying? Accordingly, given the court's application of health, the irregularities or flaws in the Worcester matter, and the remedial measures taken by the Commonwealth and Special Prosecutor Cosgrove, the circumstances before the court cannot survive the close scrutiny required before taking the very substantial and exceedingly rare step of disqualifying counsel. XOXO, Judge Belazos. Tassical says, Lindsay Gattani named him, Cosgrove, personally in a document that she filed with the courts. That's the conflict. Yes, that's why I wanted to go back and look at the papers, because I couldn't remember if she just sued the DA's office as a whole or if she personally named Cosgrove, and she did. She did. We just saw it. Let's take a look now at Cosgrove's contracts. Because, you know, like I always say, follow the money. All right, let us look at the 2024 payments to Cosgrove. Let's do that first. Wait. We've got payments, and then we've got contracts. Let's do the payments first. Or because his payments started in 2024, I believe. That's when he first came on board, right? All right, let's take a look. All right, here we go. In 2024, Robert Cosgrove was paid a total of, this is the checkbook from the Norfolk DA's office, $27,888.64. There was one payment made on July 16th of 2024. Remember, he was billing monthly, so he bills every month. So his first month of billing in 2024, he was paid $17,000 and change. His second bill was paid August 1st, 2024, and that is $5,161. And then his third payment was made to him on September 11th of 2024 for $5,566. Remember, he came out of retirement to handle this case specifically. In 2025, Cosgrove was paid beginning in, let's see, how far down does this go? Well, wait, hold on. There were more payment. 2024 October, he's paid $11,000. I don't know why that was billed late. June 5th, 2025, he was paid $25,000. And also June 5th, he was paid another $23,000, almost $24,000. The total billings for 2025 are $89,143. And remember, he was only hired at this point to prosecute Aidan Kearney. August 13th, he was paid $16,000 and change. July 21st, he was paid $11,000 and change. June 5th, he was paid $23,000 and change. And also on June 5th, he was paid $25,000 and change. Those are the payments we just read. And then as of 2026, this was early in the year. He had already been paid $33,000. But then here's another payment, December 17th, 2025. He paid $21,000. September 25th, 2025, almost $12,000. This is why Howie Carr calls him Triple Dip Cosgrove. Triple dip, because he's getting a pension. I forget what his first job was, but his second job was as a judge. Maybe his first job was as a prosecutor. Makazi, geez, he's here. Yeah, I wanted to meet him that day, but they ushered him out the Kazi staircase. He was paid all that money to watch Turtleboy episodes. That's right, not a Haas defendant. You are correct. This is your money. These are your tax dollars. Ipsy Dixit, because I said so. Thank you, big old dog, for coming to play today. Thank you to Glamasus for sending me these documents a very long time ago, all the way back. When was this that you sent this to me? Oh, I guess it was only in January. It feels like a long time ago. It's only March. Let's take a look at the contracts between the Commonwealth and Cosgrove. This is the contract between the Norfolk DA's office and Robert Cosgrove for 2025. Follow the money. Well, this is interesting. I mean, you know about all the misspellings that we commonly see, right? Look what it says. Contractor legal name, Robert C. Cosgrove, Cosgrive. It's between Robert Cosgrove and the Norfolk County District Attorney's Office, as you can see, at the top. That's my cursor, not a fly on your screen. And it goes on to say budget fiscal year 2024. So this must have been a renewal. Okay, so no, this was a new contract as of the date of signing. The procurement is department procurement for the Norfolk DA's office. Standard Commonwealth terms and conditions with a maximum obligation contract of $40,000. Well, we did say that he was paid more than $40,000 in 2025, right? So I guess they had to keep going back and asking for more money. It gives them 45 days to pay, according to their prompt payment discount cycle. And here it says that his rate is $400 per hour. That's the attorney rate. Is that the same as they were paying Brennan? Anybody remember? $400 an hour? Hold, please. Which is, considering that people like Bob Alessi charge in excess of $2,000 an hour, not a huge amount, but the public defenders in Massachusetts are getting paid how much? Like $80 an hour? Okay. The anticipated start date, March 13th, 2024. The contract end date would be the end of the year, December 31, 2024. Signed by Cosgrove and Margaret Krippendorf, who was in charge back then. $85 the public defenders make. Thank you, Marcello. B. Crum says they were making $65 an hour when the 100 cases were dropped. Yep. 60, 65, somewhere around there. It's a great gig if you can get it, right? In retirement. And they seem to pay him pretty promptly. So he's got that going for him. And he continues to be paid. Oh, so yeah, then what had happened was, here's another contract from 2025. And I guess they went back and asked for more money. I remember we went over this. Budget fiscal year 2025. This is for 2025. Amendment amount, $40,000. Yes, they wanted to another $40,000 because the first one was only for 40. Then they came back and asked for another 40 for a maximum obligation of 80,000. And this end contract date is June 30th of 2025. But he's still going, don't worry. There's DocuSign. But wait, there's more. Oh, they wanted another $25,000, June 30th of 2025. Another 25 grand. $400 an hour. Special Assistant District Attorney Services with the Norfolk DA's office. I believe that at one, it was for 4,000 empty pages, says Magazi G. 4,000 blank pages. I'm sure there's a time where they were paying both Mello and Cosgrove at the same time, right? But wait, there's more because I think there's another document attached here. Let's see. Yeah, so we have a 2026 contract. Oop, let's take a look at that. Because it never ends. Never ends. This is the standard contract form for 2026 against Robert Cosgrove. They spelled it right this time. Commonwealth terms and conditions. $400 an hour. This goes through June 30th of 2026. You can do a FOIA request and you can get the updated contract if there is one. It was signed on September 9th of 2025. And this one indicates there a cap on this one? $45,000 cap. You see here the maximum obligation contract. I can't highlight this because I don't have it pulled it up that way. At $400 an hour. And since I was sent this, I think back in January, who knows, there may have been an amendment to this already. They may have went in and asked for more money because Cosgrove not only now is working on the Aiden Kearney matters, but he's also working on the Karen Reed matters. Somehow, some way. And we don't know if he's been specially retained to prosecute Karen Reed. I would imagine that he is, but we wouldn't get to see that because that would be work product. So we wouldn't get to know the exact details of his engagement, as it were. Jamie says 2027 needs to hurry for a new DA to clean house. Yeah. Who are you going to vote for, Jamie? Are you able to vote in Norfolk County? Happy St. Patrick's Day, Holly Johnson. Thanks for being here for a year. Thanks, Mima, for your compliment. I appreciate you. And thank you for thanking me. And thanks for being here for 9 months. Eman, good morning. Thank you very much for your compliments. Thanks for all the classes you teach us on these cases. I would be lost without you. Happy St. Patty's. Thank you for being here for 16 months. Yeah, there's a new 2-year cupcake. So if you guys see that you have a new color cupcake, I was able to add that in. Michelle Roy, happy St. Patty's Day. Thank you. Thank you for your compliments and for being here 15 months. States both my boys are born in December, 2 years apart, products of the Southie Parade in Boston. Thanks for your 5 stays. Tashai says the judge from Canton, and he replaced Kazi. Yes, he was a judge. Was he from Canton, Cosgrove? I don't know. But he was from Norfolk County. Judge from Norfolk County, and he replaced Cosgrove as the judge in this case, Belizos. Okay. Judge Belizos is from Canton, and he replaced Cosgrove as the judge in Norfolk County. But he claims to be fair. It doesn't seem like it. Can they try to replace the judge? Free Turtleboy now. Shaking my head. Massachusetts is so weird because apparently, and I learned this from the Mazza fundraiser the other night. So if you guys didn't watch it, it was about Kelsey Fitzsimmons. Lori Mullen was on. She's a family law attorney in Massachusetts. And she was telling us that judges need to be specially assigned for trial. Here in New York, the judge that you get assigned to your case when you file an RJI or is the judge. The judge is the judge till the end. Apparently, who knows if this judge is going to be the judge to try Turtleboy's case? We don't know. And so, as we saw in Kelsey Fitzsimmons, it has gone from Judge McCarthy-Nyman to Judge Drexler to Judge Karp. And apparently, we still don't even know if Judge Karp is going to be the judge who's going to be sitting on the Kelsey Fitzsimmons trial. I mean, I think it is, but anything can happen. You always can make a motion to recuse a judge. But we've seen the way that works out. We saw it in Karen Reed, Judge Cannoni. Even when they had a good faith basis, in my opinion, to have her recused, she heard the motion herself and she didn't recuse herself. So I don't see a basis for recusal here. Just because you don't like a judge's decision doesn't mean that you can have them recused. In the Karen Reed trial, before trial number 1, they made a motion to have Beverly, Judge Cannoni, recuse herself, alleging that she had personal relationships with some of the parties and or witnesses in the case. And they had receipts, and it was denied. So I don't think it would be successful, but like you're thinking outside the box. Thanks to Shy for your 5. Husky Lover, thank you very much for your 20. There's no question there. Division Bell, closing in on a new cupcake. Oh, that's right. In a month, you'll get a new one. Thanks for being here for 23 months. Melanie's interruptions. Thank you. I'm a little behind in this live, but Cosgrove needs to put an egg in his shoe and beat it. Thanks for your time. Cupcake Diary says, accidentally hit unsub. Got to wait 48 hours to chat. Listen, it's for your own protection as well as mine. I did hear that the Haas defendants YouTube channel has something like an 8-week wait. Is that true? Is that true that you have to wait 8 weeks to chat? I don't watch that channel, but I don't know if it was a joke. 48 hours. In the grand scheme of things, is not very long. Although the trolls will wait 48 hours to come in. They're very tenacious and very patient. Lil, the good dog says, top of the morning and happy St. Pat's Day from a former Irish step dancer. Oh, that's amazing. How fun. Thanks for keeping it real. You know. Thanks for your 5, Lil, the good dog. Any other Irish step dancers in the chat? That's amazing. Yeah, they do always hear their motions to recuse themselves, Mastad. Some other states don't. I think it was, can't remember which trial it was that we watched, but it did go to a different judge. But the different judge did not recuse the other judge either. It's hard to get a recusal. I mean, you have to have some pretty strong grounds for it. Double Trouble says, I sent an email with Stowe's page regarding Justin's house. I think we've looked at that before. I don't know if you sent me an email and told me where to find it, but I couldn't find it. So thank you for your super chat. But I'm not talking about that right now. Adrian, thanks for becoming a member. How dare you? Has been here for 19 months. Favorite thing to say to reception is hello, beautiful. Oh, you mean for compliments? Oh, thank you very much. How dare you? And Vanessa became a member. Welcome. Sleepless Sleuth said, I think that grand jury was Karen Reed and Turtleboy conspiracy. You mean the one in February? Not the one that she actually was served the subpoena for, because that was a different grand jury. Thank you for being here for 4 months. Fairy Raven says, Melanie, whoever said St. Patty's Day is a slur needs to give their shamrock a wobble. It is not. I love you with all my heart. Oh, I love you with all my heart too. Slancha. Anybody drinking green beer today or right now? My Labrador's mom said, let the shenanigans begin. Massive shenanigans. Thanks for your 10. Mama She has been here for 19 months, and she says, I'm late, but I'm here for the shenanigans. Happy St. Patrick's Day. Happy St. Patrick's Day to you. You're very, very sweet. And Betsy, thanks for your Venmo, says, happy St. Patty's Day. And Philip says, thanks for your hard work via Venmo. Thank you guys so much. Friend of the Dog gifted 10 memberships. 10 memberships. You're super generous. I really appreciate you. Thank you so much. Lena wants to know, can Aiden appeal this ruling? It seems like such a conflict. It does. Can they? Maybe. There's limited things that you can appeal before a case is completely over. And off the top of my head, I don't know if this is one of them. Will they waste the time and money doing it? I don't know if it's worth it. Appeals are expensive. He's already spent a lot of money on attorney's fees. Is it worth it to have Cosgrove disqualified? The money would be better spent on appealing. If the mega motion to dismiss is denied, I think the money would be better spent appealing that than this. Could they appeal them both in the same appeal? Mastad, that's a great question for you. Thanks for your 5, Lena. Jamie said 2027 needs to hurry up for a new DA to clean house. Irish Reel is a dance, the REEL. All right. I'm going to go look those up on YouTube later, those videos. Thanks, Lola the good dog. Okay, so the 27th is off now, you're telling me, right? So Aiden's case has been pushed to, somebody tell me again, what's the new date so I can put it in my calendar. And that is because Kelsey Fitzsimmons' trial is scheduled to start on Monday, the 23rd. It remains to be seen whether or not it is going to be a bench trial or a jury trial. If it's going to be a jury trial, jury selection will start on the 23rd. And that judge said in the Kelsey Fitzsimmons case, it is likely going to take 2 to 3 times longer to pick a jury than to try the case. So May 14th. Thank you, Makazi G. Oh, Makazi G, you're actually on top of your calendar? All right. So for those of you who were intending to go to Suffolk Superior Court on the 27th of March to support Aiden Kearney, that has now been pushed to May 14th due to what I believe is the conflict, the potential conflict, definite conflict of Tim Bradle, who will be trying the Kelsey Fitzsimmons case. May 14th at 9 a.m. All right. We will cover that. Tomorrow, there's also another hearing on Kelsey Fitzsimmons. Tomorrow is a travel day for me, so I can't cover that, but let me just hang on one second and ask and find out what time that is for you. I can't cover it live, but I can cover it on the replay. Tomorrow, Kelsey allegedly has a hearing tomorrow at 10:30. And I don't know if it's in person or in Zoom. I'm not sure. Kelly Dever, reason for resigning. I want to. You want to resign? Kelly Dever? Is that new information or is that old information about her resigning? Oh, did I see Dever's resignation? No, but I guess I need to find it. So, hold please. I thought that was old news. Or was it old news that she was just on leave? Hang on one second. Oh, okay. Well, let me just finish this thought before we move to that. And this thought is that Detective Haldeman, who we were just talking about from, I think, the Medfield Police Department, made a motion in the Kearney versus Gattani case to dismiss. And this happened February 9th of 2026. And so let's just take a look at that real quick. So Sergeant Detective Dylan Haldeman made a motion to dismiss in that same case in Worcester. And this is just the first page with the endorsement on it from the judge. It says Sergeant Detective Dylan Haldeman moves this court to dismiss Ms. Gattani's counterclaims against him. Again, with the air quotes. Ms. Gattani's claim fails to comply with the procedural requirements set forth in Rule 14 and fail to state a claim upon which relief can be granted under Rule 12b-6. Sergeant Detective Haldeman hereby moves this to dismiss defendant's counterclaims in their entirety for the reasons stated in the accompanying memorandum. It says the moving party, Sergeant Detective Dylan Haldeman of the Medfield Police Department, does not appear in the caption because the defendant, Lindsay Gattani, is improperly attempting to add him as a party in her answer to the plaintiff's Aidan Kearney's complaint. While he also was not served, Sergeant Detective Haldeman moves to dismiss as he is listed in the docket as a defendant. So he was never served. He was never served. And then on February 9th of 2026, absent opposition, the motion is allowed. So apparently Lindsay didn't oppose it. And so the claims against Haldeman have been dismissed. And he also says that he wasn't served. So there's that. Maybe Cosgrove wasn't served either. Maybe it is procedurally defective because they were not third-party data as defendants. And I don't see that that was ever amended. Was she able to file a case against them directly? That remains to be seen. All right. Thanks, Cherie. Hold on. I think we need an empowerment card for today. All right. Well, but this is dated August 18th of 2025. Okay. Did somebody get this pursuant to FOIA, Suzanne? Oh. Kelly Dever. Poor Kelly Dever. That's the wrong page. Hold on. You can't make this up. You can't make this up. If you tried to like script this in Hollywood, people would the studio would laugh at you and say, this is just so unrealistic. Nobody's ever going to believe this. Here it is. It is Kelly Devers' official resignation from the Boston Police Department, dated August 18th of 2025. And it reads as follows. To the police commissioner for the city of Boston, I, the undersigned, respectfully tender my resignation as patrol officer. She filled that in with her handwriting. Attached to assignment E13 to take effect on September 1 of 2025 at 4:00 p.m. The reason for resigning, she just wrote in there, I want to. I want to resign. Question 1, is the resignation presented while charges are pending? No. Question 2, is it requested that the 7-day rule be waived? No. Respectfully submitted, Kelly Dever. There's no witness to her signature, but somebody did approve it. August 18th, August 20th, August 28th. I remember this breaking in September. Emily. Hi, Emily C. Didn't the news of Kelly Dever resigning break when we were at the Wilbur in September? Because I guess it was kept quiet for like a whole month before we found out about it. I think that's when the news broke, because I remember it happening like during the show. People were talking about it, right? Yes. Yes, Courtney, it did. That's what I thought too. I don't remember what day it was, but I think that was sometime in September of 2025. But I can't believe it was secret for so long. And this is from Kyle Sharkey. Look at you giving Kyle Sharkey the shout out. Credit where credit is due. Living Story World, my 25-year-old son seeing me on the screen says that I'm stunning. Listen, he's young enough to be, he's young enough to be my son, but I'll allow it. Thank you. Thank you. Your son is very nice. Thank you so much. Gen X says, I've shunned before and shall shun again. Thanks, Gen X. Because I want to, says James. Because I want to. She could have absolutely given all the details. Well, that is short and sweet, right? Short and sweet. Where is Dever trying to go for work now? Turtleboy keeps hinting at something. Oh, I don't know. I don't know. I have no time to watch anybody else's shows. So unless you guys tell me about stuff, I don't see it. Hi, Scott McGinnis. He says, if I were Kelly, I would write, I was thrown into the cogs of the corruption machine. I haven't fared well, a bit messed up, but still alive. I am out. Right. She has very nice print. Here's the thing, like our kids, I don't know if anybody has high school kids or college age kids right now, but their handwriting sucks. It sucks. I'm sorry, but I'm not sorry, because they were not taught penmanship in school, because they've been typing the whole time, right? They've been typing. Living Story World says, because I want to. That tells me that it isn't her who wants to, because she's making a clear point to point out that she is. Right. Thank you, Maureen. We just looked at them. They're from August of 2025, but we just looked at them now. I don't know where she's working, but I would prefer that we don't talk about where she's working, because there's some really crazy people on the internet. Really crazy people on the internet. Would you agree? Because I want to. Can we get I want to merch? Maybe. Maybe we can. Let's pull an empowerment card. How about that? Oh, please. Oh, yeah. The arraignment dates for Enrique Delgado Garcia case. I got those for you, too. Let's do a couple other Massachusetts things. And I had a lot of other stuff that I wanted to cover, but I want to say, I take your pulse on this Afro Man trial. A negative mind will never give you a positive life. Say it a little louder for people in the back. This is our empowerment card of the day. A negative mind will never give you a positive life. There it is. Because I said so. Ipsy Dixit. Ipsy Dixit. All right, let me pull up my notes on the other Massachusetts things that I had for you today. It is March 17th. Well, this is not Massachusetts. It's March 17th, 2026, and still no Nancy. Still no Nancy. Is that story still a thing? The Nancy Guthrie story, is it still a thing? I don't know. Still no Nancy. Apparently, Megyn Kelly says that Savannah Guthrie is really, really mad at Ashley Banfield for even insinuating that her brother-in-law had anything to do with it. But that's according to Megyn Kelly, who says that Savannah is mad, not specifically at Ashley Banfield, but about people saying that the brother-in-law was involved. But Megyn Kelly can't confirm, she cannot confirm that Savannah has said she may be suing Ashley Banfield. So there's that. This was interesting too. Do you remember the other day that we went over Karen Reed's amended complaint, right? Right? And do you remember whether it was a big whoop or not? Do you remember whether we thought it was a big whoop, her amended complaint, because she does have the right. She absolutely has the right to amend it. It's in federal court. She had to put some federal statutes and stuff in there. Well, the Haas defendants have sort of, I don't know, maybe given a statement about their thoughts, maybe, on her amended complaint. Did you see this? This was published on Friday on the Twit. Check this out. I mean, these people, I mean, tell me, is this, because I don't wade over there. I don't engage on Twitter. Testify defending the truth. This is is this the official Haas defendants spokespeople? Is this the four ladies who have the YouTube channel who speak on their behalf? I don't know. But I think this is supposed to be the official thing. But here's what they said. What was supposed to be Karen Reed's response to our motion to dismiss turned into a 54-page amended complaint. Well, it says ours. So unless they're adopting the voice of the Haas defendants. And reading through it, you'd think the last two criminal trials never happened. I'm sorry, was she acquitted of hitting John O'Keefe with her car? Because we know those happened and she was acquitted of hitting him with her car, right? So many of the allegations against us in this amended complaint are presented as if none of the evidence from those trials exists, as if the record doesn't contradict them, as if the testimony never occurred, as if the scrutiny of two full criminal proceedings simply didn't happen. Well, here's the thing. Here's the thing about this amended complaint. And we know because we went over the whole entire thing the other day. In fact, I put the complaints side by side so that we could see every single thing that was added. And there wasn't a lot added to it. Really, the only things that were added to it were Jen McCabe's exact times of her deletions and her steps and her pacing and her phone calls. And so there was a lot more detail in there, and all of the stuff pretty much that was added to the amended complaint was data. And so there's that. So did they not read the first complaint? Because there's really not that much more in the amended complaint. But anyway, let's keep reading. Instead, we are apparently expected to step into Karen Read's fairy tale world where inconvenient facts disappear and narratives get rewritten. Well, that's what a civil lawsuit is. It's the plaintiff's version of events of what happened. And you could say the same thing about the O'Keefe's complaint against Karen, because that is a little bit more straining of credulity straining, because she was acquitted of hitting John with her car. But I digress. But here's the real problem. Filings like this just don't live inside a courtroom. They become fodder for the same pink-clad crowd of online misfits who have spent years stalking, harassing, and targeting anyone who refuses to play along with the narrative. The same people who treat Karen Read's court filings like marching orders. Here's the thing. A lot of people probably wouldn't have even known about it except for you squawking about it on Twitter. Let's be honest about the point of this filing: to further dehumanize the witnesses, encourage continued attacks, try to bankrupt the people that did nothing but tell the truth. Their version of the truth, Melisa says, is Karen hit John O'Keefe at 12:32. Jen was looking at the car at 12:32. Karen was home at 12:36. Jen was looking at her car at 12:40 and 12:42. Well, in the first trial, wasn't it originally that John O'Keefe was hit at 12:45, and then it kept moving backwards during the course of the trial? Here's the thing. Karen Read was actually bankrupted. I don't know if she actually filed for bankruptcy, but she was. Sold her house, liquidated her 401. I mean, we could go on about this forever because we know all the details. But hear this clearly. We will not stop. We will not be bullied into silence. We will not be hunted out of telling the truth. And we will continue to fight for the truth and accountability for our names and for John O'Keefe. You know who else will? Yuri Buchanan. That was also added to the amended complaint. And that was 100% true. Yuri Buchanan posted your fundraiser on his social media platforms, on the Twitter, on his Facebook, asking for donations for you. And he, as a sworn officer, is supposed to be non-biased. Is that not true that he did that? We will not stop. We will not be bullied into silence. We will not be hunted out of telling the truth. And we will continue to fight for the truth and accountability for our names and for John O'Keefe. Okay, and you're entitled to do that. And you know when a really good time to do that would have been? During the pendency of Karen Read's trials. Because now they're over. And now all of a sudden you're talking about stuff that already is done. She's been acquitted. I mean, is it just me? I don't know. I think they had a fundraiser. Somebody said they had a fundraiser over the weekend. What did you say, Emily? It was a prom? Good job, Yuri. Said Scarlett going. Did he get his marching orders, or did he think he was going to get some of the attorney's fees? Some of the money to pay his attorney's fees? I don't know. Oh, but here's something I did find really interesting. There's a former police officer in Missouri who was just sentenced to 2 years in federal prison for looking for nudes on women's phones. Oh, yeah. Oh, yeah, he was. Listen to this. And I come with receipts, so hang tight. This is in the federal court in Missouri. Former Florissant police officer was sentenced to 24 months in prison for searching women's phones for nude images. This just broke on Wednesday, March 11th of 2026. In St. Louis, this is the official press release from the U.S. Attorney's Office for the Eastern District of Missouri. St. Louis U.S. District Judge Henry Autry on Wednesday sentenced a former Florissant, Missouri police officer to 24 months in prison for illegally searching the phones of 20 women for nude photos and ordered him to pay $2,681 in restitution to his victims. Julian Alcala, 31, pulled the women over while on duty in uniform and in a marked police vehicle between February 6th of 2024 and May 18th of 2024. Alcala took mobile phones from 19 of the victims by claiming he needed to go back to his patrol car and use their phone to confirm insurance coverage. He told the 20th victim that he was confirming her vehicle registration. Alcala then searched through the phones without a warrant, probable cause, or a lawful reason. When he found images that portrayed either the victim or a loved one or both in a partial or full state of nudity, he used his own cell phone to take photographs. Alcala also found and forwarded a video of one victim to his cell phone. When that victim discovered the forwarding of the video and reported it to the FBI, court-approved search warrants of Alcala's cell phone and his cloud storage uncovered the other victims. 25 years on the job, says, what a moron. They should have given him more time. Emily C. says, what a loser. We know from the Proctor phone extraction of 13 years, we know because the Commonwealth told us that there were intimate body parts on Proctor's phone in group text messages to other people whose body parts they were not. So if you think the FBI just forgets about stuff like this, you might be wrong. In court, Assistant U.S. Attorney Christine Krug said Alcala had violated his oath to protect and serve. Victims, she said, had previously trusted police officers, but Alcala's actions had replaced that trust with mistrust and disgust and fear of law enforcement. She pointed out that Alcala victimized 5 women in just one shift. In another, he victimized 3 women, and in a third, he victimized 2. Alcala, 30, pleaded guilty in December to 20 counts of deprivation of rights under color of law, namely the right to be free from unreasonable search and seizure. When Julian Alcala abused his authority, the damage extended far beyond his immediate victims, said Special Agent in Charge Chris Crocker of the FBI St. Louis Division. His actions dishonored the badge and undermined the public trust that every officer is sworn to uphold. I appreciate the leadership of the Florissant Police Department for working closely with the FBI to hold Alcala accountable and ensure he could no longer victimize members of the community. The FBI investigated the case. Assistant U.S. Attorney Christine Krug prosecuted the case. Yep. I don't know if Lally will ever get back on the stand. I hope so. I hope so, Jess. But wait, there's more, because there always is. There always is. This one also in the Eastern District of Missouri, and this is a former Missouri State Trooper who admits searching women's phones for nudes. I mean, it's a crime. It's a crime. The feds don't like it, and they especially don't like it at the U.S. Attorney's Office in the Eastern District of Missouri. This is from December of 2025. A former Missouri State Highway Patrol trooper on Tuesday admitted unlawfully searching women's cell phones during traffic stops to find nude pictures. I mean, what's the difference if it's a traffic stop or if it's a phone that's in evidence? And I said, when those text messages came out about Proctor in trial number 1, no nudes so far, I said, do you think this is the first time? David McKnight, 40, pleaded guilty in U.S. District Court in Cape Girardeau to 9 counts of deprivation of rights under color of law, namely the right to be free from unreasonable search and seizure. He admitted unlawfully searching and seizing photographs from the cell phones of 7 women and unlawfully searching the phones of 2 more women from September 23 to July 24 while on duty in uniform and traveling in marked Missouri State Highway Patrol vehicles. During separate traffic stops, 5 of the victims, McKnight took their cell phones away from them and to his patrol car, claiming that he needed to confirm their identification or insurance coverage. This is like a whole thing. In Missouri. All these state troopers in Missouri are doing it. Wow. I don't know. They're all doing it. Apparently it's a thing. Maybe it's a thing everywhere. I don't know. You tell me. I've never heard of handing over your phone for a traffic stop. I think maybe you shouldn't. I think maybe this is a good lesson. I don't want to advise you on the law in your particular jurisdiction. Courtney's like, why would you give your phone? A lot of people do what the cops tell them to do. It should be called Proctor's Law. That's Nicole. He arrested another woman and took possession of her cell phone. Incident to her arrest, he encountered another after an accident, one after a breakdown. He searched their phones without a warrant or probable cause to find nude images of the victims or their loved ones, and then used his own cell phone to take photographs of some of the images that he found. After 2 victims became suspicious of his actions, they reported him to the MSHP. Forensic analysis revealed that McKnight had to search through their phones, going into folders that contained nude photographs of them. Subsequent investigation revealed evidence of the other victims. He will be sentenced on March 24th of 2026. Yes, Cosgrove has not been disqualified. Nope. He has not been. Well, of course it was denied. Of course. Because then they'd have to go outside the county to find somebody else. And they know, I think, that nobody else wants to touch it. And I don't think it's a shock to any of us. The FBI investigated that case in Missouri, and the assistant U.S. attorney, same one, Christine Krug, prosecuting the case. Gene said, if your insurance card is on your phone, get a paper identification card. Don't hand anyone your phone. Great advice. Great advice. Keep a paper copy of your insurance documents in your glove compartment. And the same thing goes for your registration. That's a great point. Great point. So if you got one thing out of today's stream, let that be it. Paper copies, because apparently those guys in Missouri, they're going to search your phone for nudes. Also, don't have nudes on your phone. How about just that? Like, try not to do that in the event that somebody could see them. Maybe you don't want to do that. Just my opinion. Let's take a look at the new court dates for the 4 troopers who have been indicted with regard to the death of Enrique Delgado Garcia. Hold on. Let's go to Boston 25 for the coverage.
Boston 25 has learned 4 members of the state police charged in connection with the death of a recruit now have their first court date set. Sergeant Jennifer Penton and troopers Edwin Rodriguez and David Montanez will be arraigned on April 2nd. Casey Lamont will be arraigned on April 14th. All 4 are charged with involuntary manslaughter in the death of Enrique Delgado Garcia. They're currently suspended without pay by the commission that oversees officer standards and training. Delgado Garcia died after a boxing exercise in September 2024. Sources told 25 investigates he suffered broken bones and a spinal injury. An independent investigator says the 4 charged allowed unsupervised, unauthorized, and unapproved boxing exercises. They are free pending trial.
Ooh.
Holy mackerel.
Oh, super annoying. All right, so April 2nd and April 14th. I'm not sure why they're doing it on 2 different days, but they are. All 4 are facing involuntary manslaughter charges and remain suspended with pay pending further legal action. Special Prosecutor David Meyer first announced the indictments on February 9th. And their names are Sergeant Jennifer Penton, Trooper Edwin Rodriguez, Trooper David Montanez. They will be arraigned on April 2nd, and Casey Lamont will be arraigned on April 14th. And if you are not aware of the circumstances of this case, Enrique Delgado Garcia died following a boxing exercise at the state's police academy in September 2024. An independent investigation determined that the 4 defendants allowed, quote, unsupervised, unauthorized, and unapproved boxing drills to take place. The injuries to Enrique Delgado Garcia included broken bones, damaged teeth, and a spinal injury. During the exercise before his death, I will tell you that the actual injuries are far worse than they make them seem. In fact, I think the family said in the beginning that all of his teeth were broken. He had not just a spinal injury, but fractured vertebrae, a broken neck. And I don't exactly recall what the other injuries were, but they were horrific. Thank you very much. Finally, and we didn't hear anything for a really long time, September of 2024. And their indictments were just announced within the past, well, February 9th, it says. Almost a year and a half. It took almost 18 months to do that investigation. Lola the good dog says, Kelly Devers' reason should be hello. Thanks, Charlie, for your super chat. Reason for resigning. Dever, quote, do you want the real answer or the safe answer? Thanks for tuning in from down under. Blessed Texas Lolly says, love and appreciate you. Free Can't Read and free Turtleboy. Or free Kelsey Fitzsimmons and free Turtleboy. Thank you. And Lemonade, thanks for becoming a member. James says, thanks for your 10. Melanie, these are the same people stalking and taking pictures of us who disagree with them. Watch your back, and what you say online is their favorite thing to yell. Oh, is that what they're doing? Are you over there playing? Are you playing in the dirty sandbox over there? I mean, your choice, James. Your choice. I say, my choice is no. Thanks for your 10. Wait, what? True crime? Thanks for your 10. Says happy St. Patrick's Day from Wait, What? True Crime, San Francisco, Irish Cupcake here, and super fan of the super amazing Melanie. Oh, thank you so very much. Free Can't Read. Free Can't Read. I'm imagining that more Kelsey Fitzsimmons motions may come out, but there was one motion that I have from yesterday about some text messages. If you would like to take a look at that. We can do that. I'll just close some of these windows because it's getting awfully drafty in here. Yes, we covered that. Thank you, Mama Lisa. Turtleboy's motion was moved because of Kelsey's trial to May 14th. If you're just tuning in. Oh, can we just talk about for 1 minute? Did anybody watch Harry Styles on Saturday Night Live? Did anybody watch that? Jennifer Penton was on a show called Boston's Finest with Brian Albert. That's correct. You're right, Toots. You're right. Oh, James, you're not on there at all? Good. You got to stay safe. Safety first. Okay. There was a very funny sketch. SNL isn't always that funny anymore. It was funny back in the day of, John Belushi and Chevy Chase and Dan Aykroyd and Gilda Radner and Jane Curtin. And there was a funny sketch involving a courtroom scene with Sebastian Maniscalco being appointed as the public defender. Did you watch that? Because there is a guy on SNL, and I can't think of his name right now, who does a dead-on impression of Sebastian Maniscalco. I'm going to show you only a tiny little clip of it because SNL will probably strike me. But Sebastian Maniscalco posted this on his twat. And Sebastian Maniscalco says, I've been on SNL twice now, which sounds impressive until I tell you neither time was. Oh, wait, I freeze, I think, when I do this. Hold on. Well, let me start again. Sebastian Maniscalco wrote on his Twitter, I've been on SNL twice now, which sounds impressive until I tell you neither time was as the host. At this point, Harry and Marcello, his name is Marcello, have logged more rehearsal time as me than I have. Both of them were hilarious and absolutely nailed it. Maybe the third time I come in and I do it myself. And so he posted a little tiny clip. Let's take a look of the Marcelo Hernandez. Thank you. Marcelo Hernandez. I'm not sure how he pronounces it, but that is the actor who does the impersonation of Sebastian Maniscalco. And I just want to show you this so you can go look for the full thing on YouTube. But he was appointed by Judge Kenan Thompson to be the public defender, and Harry Styles was the prosecutor. Okay, here we go.
For my client to get out of that store, he would have had to juke out a security guard.
It was a theft case. It was a theft case. I thought this was really funny.
Then they got the lasers everywhere, so my client would have had to Tom Cruise that. Okay? And then they got the sensors. You know about the sensors, Your Honor?
I have to keep interrupting it because, fair use and all. This is my commentary on Sebastian Maniscalco being impersonated by Marcelo Hernandez.
About this store, the sensors, they tell you you got something you're not supposed to have. So my client would have had to grab the shoes and the belt and the jacket and hold it above his head and go like that.
Oh, and that girl who plays the court reporter, she's really funny too. I forget her name. Jane, remind me. She's funny.
So either my client is not guilty or he belongs in the Olympics. The defense rests.
I mean, it's funny. You can go find the whole thing on YouTube. I know Harry, and he smacked Harry's butt in the end. Remember Rosanna Dana? Yep. So funny. All right, let's just, maybe we could fast forward it to Harry getting smacked on the butt.
Maniscalco is talking. Like, what if I talk like that?
Listen, it's very rare that the musical guest also does sketches, and I thought Harry was good. I thought he did a good job. He's a pretty good actor. He's funny.
Your Honor, this guy took the clothes and he walked right out of the store. We got the security footage. After. So, ladies and gentlemen of the jury, I ask, why would he do that?
Well, that was funny. I think that was funny. Well done. It was a good episode. You can go find the whole entire skit on YouTube. And he does get smacked in the butt by Marcelo Hernandez. It's very funny. What was I talking about when I interrupted myself to tell you that? I'm Gumby, damn it. Yeah, I'm Gumby, damn it. PJ Wolf, thanks for being here for 10 months. You're awesome. Slancha, Ms. Bouquet, thank you for your super sticker. Donkey's Noggin says to all the haters, yacht on this. Yacht today, Satan, not today. Thanks for your 5. And Kim Martin says, this is my favorite place to be. Thank you very much. Thank you very much. Oh, yeah, the thing about the emojis was very funny on Weekend Update, too. And I actually found that tram emoji on my phone. I had no idea that it existed. That was so funny. That was very funny. I thought so, too. But I feel like, I don't know, I feel like maybe I've aged out of it. I feel like their demographic skews way younger because I feel like a lot of people might not have even understood that. And there are a lot of sketches that I'm just like, I don't even know what they're talking about. Like when they do the sketches with the, the 12-year-old YouTubers and gamers. I have no idea. I have no idea. It was funny. All right, let's see what else I have for you today. Oh, you want to look at Kelsey's motion? Let's look at Kelsey's motion. Her phone records. Shall we do that? Let me just find it for you. Talk amongst yourselves for a moment. Talk amongst yourselves. Mm. Thank you, Tiffany, for sending this to me. Okay, this is the Commonwealth's motion in limine. Let me just move this over here. Getting all kinds of things done today. All kinds of things. We're catching up. We're cleaning up. And we still haven't even talked about Afro Man. Because I got high. Do you guys remember that song from 2000? I think that song was, I looked it up. That song was from 2000, 2001. Google it. You might remember that song. Police served a warrant on him and did a search of his home, Afro Man, the rapper. And they tore his home apart. They didn't find anything that they were looking for. He took his own surveillance footage from his house, made a video about it because they wouldn't pay for the damages to his house. He made a video about it, and something like 7 of the police officers who were involved in the search warrant execution inside his home are suing him for defamation. And the trial started yesterday. And so far, from what I see, it looks interesting. He made another video to try and get his gate fixed. I mean, the story's wild. I found the lawsuit. If you guys want to do some of it later, I'm happy to come back and do it with you. If you want to, I'll set it up and teleport you over there right now. Afro Man says they stole money from him too. Yup. That is true. All right, let me just change my banner here too. I just wanted to take your pulse on whether you guys wanted to cover it. I find it very interesting because it's another First Amendment question. You know, these police officers are like, yeah, he disparaged me. He called me this. He called me that. It's a First Amendment case, and they're suing him. Okay, let's take a, okay. Let me change that to that. Then let's take a look at Kelsey Fitzsimmons, or the latest motion to be filed in the Kelsey Fitzsimmons case. It is the Commonwealth's motion in limine to admit the defendant's text messages from the day of the assault. And this was filed, I don't know when, recently. I'll see the date when I get to the end of it. Now comes the Commonwealth and asks this honorable court to admit text messages between the defendant and her former fiance, Justin Alayan, on June 30th of 2025. So text messages between Kelsey and Justin. The Commonwealth says these texts are admissible to prove the defendant's motive and state of mind on June 30th of 2025. As an initial matter, the defendant's text messages, even if admitted for their truth, are not hearsay because they are statements of a party opponent. However, the Commonwealth is seeking to admit the texts not for their truth, but to prove the defendant's motive and state of mind. Prior bad act evidence admissible to show defendant's motive, intent, state of mind, or the hostile relationship between the victim and the defendant. Determinations of the relevance, probative value, and prejudice of such evidence are left to the sound discretion of the judge, whose decision to admit such evidence will be upheld absent clear error. What could these messages possibly say? Now, correct me if I'm wrong, because is June 30th, we know June 30th was the same day that Justin went into probate court ex parte and got the restraining order and the take the baby away order, and that the incident of the shooting happened that same day in the evening hours, I believe. But do we know if June 30th was the same day that Justin told Kelsey to meet him at the park and left her hanging there for a couple hours? Was that the same day, or was that maybe the day before? Right. Motive for what exactly? Motive for what? Okay, here you go. This is page 2. In this case, the texts demonstrate that the defendant was aware that her relationship with Elaine was in dire jeopardy. Our love's in jeopardy, baby. Her texts from June 30th, 2025 alternate between hostile and pleading. Maybe because he was gaslighting her. Therefore, when the defendant heard Elaine in the residence, she acted out of anger and desperation when she pointed the gun at Patrick Noonan and pulled the trigger. Really? Do you think that she said in those messages to Justin, if you send somebody over here to serve me with an order to take the baby away, I'm going to kill them? Do you think that's what they said? Here's the problem for the Commonwealth on this, okay? It's in the paper somewhere. It's in the paper somewhere. We've read it before, and I don't remember if it was the family court or if it was in Tim Bradle's motions somewhere. But we know, we've read that Justin allegedly told North Andover PD, listen, when you go serve her with this order, she may try to hurt herself at the baby. Allegedly, he said that. They've got a problem because North Andover PD was on notice. They were on notice that something like this could happen. And the fact that they came into her house and did not secure the weapons right away, that's a big problem for them, especially since Justin told them something might happen. So, of course, they want to do everything they can to try and win this case, right? To save themselves from a whole lot of civil liability. Because North Andover PD has paid out a lot of lawsuits recently. We looked at them. One of them was from the Sergeant Gerke, Katie, who gave Justin permission to break into the house, allegedly, maybe, kind of, sort of. She had filed a lawsuit against Chief Gray and the North Andover PD, and they had just settled that lawsuit in December of 2025. Okay? The texts are also relevant to put the assault in context. The prosecution is entitled to present as full a picture as possible of the events surrounding the incident itself. In this case, the texts demonstrate that the defendant's relationship with Elaine was already in the process of devolving even prior to the service of the restraining order. Okay, so what? I don't think she's going to deny that. In fact, they were in a fight. They got in a fight at the Jack and Jill bachelorette party. I don't think that that's in dispute. Right. She was at the police station earlier that day. Right. She was going to a CPR class. She was with the baby. They were all nice to her. They knew what was going on because apparently somebody said, oh, you should give Kelsey her radio back. She's coming back in a couple of days. And then somebody else said, no, don't do that because you don't know what's going on. Yeah, she was shot in the evening of June 30th. So she could have been texting Justin earlier in the day because I think that was the same day that he said, come and meet me. Come and meet me at the park. So she could have been texting with him. And that's what they want, her text messages with him. The texts are also relevant to put the assault in context. The prosecution is entitled to present as full a picture as possible of the events surrounding the incident itself. In this case, the texts demonstrate that the defendant's relationship with Elaine was already in the process of devolving even prior to the service of the restraining order. Therefore, the Commonwealth requests permission to use the texts from June 30th, 2025 in its case in chief, subject to an appropriate limiting instruction by the court. XOXO, Paul Tucker. District Attorney by Marina Moriarty. Commonwealth is desperate and acting like it, says Jess. Yeah, did he acknowledge that he had moved out of her house too? Did he say anything like, I got to come and get my stuff? Was he trying to placate her while he was in court? Trying to get the take away the baby order and the restraining order? I would love to see those text messages too. Are they going to, I mean, the Commonwealth has already said they don't think they're going to call Justin. So wouldn't they need Justin to authenticate the messages? Right. They would have to call him to authenticate him. Although if they came from her phone, from an extraction of her phone, maybe they could get him in another way by having a witness come in and saying they did the extraction, etc. Nancy, thank you so much for your 50. Melanie, you want funny? Go listen to Aiden trying to explain what baptism is all about. All right, I'll do that. I'll do that next. Thank you, Nancy. For your 5, I appreciate you. I mean, you're 50. You're 50. You're very generous. 50. And Roberta, thank you for your Venmo. Says happy St. Paddy's Day. Thank you so much. Donkey's Noggin says to all the haters, yacht on this. Thanks for your 5. And thank you, Nancy. That's very, very generous. Is it clean enough that I can play it? IYKYK says Justin could not have been anywhere near her as soon as the restraining order was printed. Why was he there? They called him. They told him to come. They told him to come. They told him to come. And Tim Bradle said, I think in open court just last week, the police colluded with Justin because they knew he was doing this. And they said, don't give her radios back because you don't know everything that's going to come out. Could make him look worse, Jersey, but apparently they've got the text messages and they don't seem to think so. Melissa thinks it was set up by Justin 100%. Baptism insurance. If you investigated the break-in, you didn't see the text messages, Mr. DA, just asking how to now to admit them. Well, they're allowed to do that because that's what motions in limine are for. It's to either allow evidence in ahead of trial, get a ruling on it before trial, or keep it out. But there was another good comment in here and said, that said, Ashton Sugar said, being emotionally charged does not make a person homicidal. Is there text to Noonan should not be allowed? The judge ruled against even giving Justin Alayan's fire department records to Kelsey's team. Right. Priscilla says the judge has already said to keep Justin out because he has nothing to do with the actual shooting. Right. Except for his actions set the whole chain of events in motion. That would be my argument. But he could be a bad witness for the defense also. Yes. So Terry says, were there cameras before the incident inside the house? I don't know if the cameras were inside the house, but what I do know is when we saw all the video, apparently there are 240 videos of Justin smoking something outside the house within the weeks leading up to the shooting. On the day of the shooting, I think it was the exact same day, June 30th, the Commonwealth seized the entire surveillance system. So they had all of those videos in their possession. They knew about them. Those are not a surprise. And I think maybe what happened next is sometime after the 30th, Kelsey's dad, who's a security expert, went back into the house and put up some new cameras. And those new cameras are what caught Justin busting into the house. And Justin likely did not know those cameras were there, but did go down in the basement, allegedly, and rip out the security system, rip out the alarm system, disconnect the modem, steal her passport, her laptop, which enabled him to go to his parents' house in Stowe, hook up to their Wi-Fi, and pull some shenanigans maybe on the computer, including transferring money, closing bank accounts, maybe changing pension documents, accessing her health records and her hospital records. I don't know if there are cameras inside the house before the incident, but what I do know is the defense just got the surveillance system back, and that's how they got those videos of Justin smoking outside the boys' room. Nancy said, it's okay to play. It's on his YouTube channel. Right, but I know, but does he curse a lot or anything in it? All right, I'll take a look. I'm counting on you, Nancy. Hang on. Oh, please. Does it say something about baptism in the short? What is the name of the short? Right, Elaine. He called the police an hour after he broke in. That's right. And I think he probably only called the police because Kelsey's dad showed up. Right? Oh yeah, you're right. You're right, Emily. The same camera that Bustin' Justin was caught on. There's also video of the Noonan and the Gloves and the other two officers coming in to serve her with the restraining order. You're right. That was on the 30th, and allegedly he moved out on the 27th, and because they got in a fight, I guess he never came back. I don't know, something like that. But I wonder if those cameras were there on the Friday before he moved out. That's a great question. He should have known they were there, but did he? I mean, I have his shorts pulled up, and I just don't see. I mean, his video shorts, not his real shorts. Oh, he explains baptism. All right. Is it clean? Something about being, I found it. It has to do with baptism. All right. He plays my stuff all the time, so he's not going to mind if I play his stuff. Let's listen to it. This is Aiden's explanation of baptism, I think. Turtleboy explains Catholic baptism on YouTube. Here we go. That'll give me a second to do a thing off camera.
Who prays to God that the family member of a baby will be absent from the baptism, which is like the most godly thing ever, a baptism? Like, who says that? Think about the popsicle headache that's going on there. This is a major religious event, a baptism. Major. You are literally anointed. I should know this. I went to CCD. I'm Catholic. I should know this. Baptism is for like original sin, I think. Like something like we're going to bless you and God protects you. If you don't get a baptism, I think you go to hell. I forget the rules. It's really important. Okay. I know it's a sacrament. It's like the first one of 7. And I know the oil and the water. Okay. We bless you in the name of Jesus. But something happens. Something special happens. Right? It's like heaven insurance, I think. Like you don't want to not get baptized. That's bad. That's dangerous. If you're not baptized, it's like driving around uninsured, if you will. It's risky, you know, because if you die, you didn't even get baptized, bro. Straight to hell. Straight to hell. It is like insurance. It's heaven insurance. That's what baptisms are. That's the best way to put it. It is because you can get baptized and still go to hell if you're a piece of shit, you know. But if you get baptized, your chances of going to heaven drastically increase. And like if you don't get baptized, it's kind of like that. You're not covered. I think that's what baptism is for Catholics, at least. So anyway, it's a really important day. So it's spiritual. God's there. God's a big part of it. That's the theme, is God. God, you are becoming one with God. and the baby and all that stuff. Okay? It's really important. And to me, it's just something you do because you're Catholic. It's like, yeah, getting baptized. And then second grade, you get first communion. And that's just what you do. Okay. Obviously not. I'm Catholic, but I'm a sinner, like a big time. You know what I mean? But that's okay. That's also sweet because that's what confession's for, baby. That's what confession's for.
That was funny. You guys are right. That was funny. Hold on for 1 second, please. Oh, please. I need to redirect you because I'm going to do, well, let's do Afro Man at 5 o'clock. Good. Good. And I need a little time to take a little break so that I can. What just happened? So that I can come back and pick out what it is that we want to, which portions of the trial that we want to look at. I don't know where my camera thingy went. Oh, there we go. There we go. I'm back. I'm back. All right. He's a riot. He's funny. It's insurance. It's Catholic insurance. I didn't watch it again. I'll watch it again. Heaven insurance, Catholic insurance. All right. So here's what's going to happen. Do you guys know what this Afro Man trial is about? It's going to be interesting. You're going to like it. Okay. It's hilarious. It's Heaven insurance. It's going to happen at 5 o'clock. For right now, we are going to break and you're going to go eat some dinner. I don't know. You have like an hour and a half. Why wasn't her house considered a crime scene? That's a great point. That's a great point, Lola Good Dog. I don't know the answer to that. I don't know the answer to that. They cleared it awfully quickly, I would imagine, and then gave Justin permission to bust in. Thanks, Romy, for being here for 14 months. Happy St. Paddy's Day. All right, you guys, we're going to come back at 5 o'clock to talk about the Afro Man trial a little bit, watch some of maybe the openings and stuff, and some other things that I will find for you in the meantime. But suffice to say that I think you're going to enjoy it. It is savage. It is savage. Go get your corned beef and cabbage and maybe some green beer. And I'll give you a little blurb about what it's about before we get started. I've got the lawsuit and everything. So let me go do some homework. But I think the time is now. If not now, when? And if not who? Me. Okay. So I'm going to do it. I'm here for you as always. Stay cool, stay kind, stay classy. Buckle your seatbelts. We'll come back at 5 o'clock. Afro Man is being sued by the police who tore his house apart during a search warrant execution because he made a video about it using his own security footage, and they claim it's defamatory because the video went viral. Will they succeed against him? I guess that'll be up to a jury. It's in Ohio. So come back. We'll see what the shenanigans are like in Ohio. Buckle your seatbelts. I'm going to teleport you over there. Thank you, moderators. Everyone smash the like button. Smash the like button on the way in. And I will see you 5 p.m. Eastern, 1 hour and 40 minutes from now. Happy St. Patrick's Day, my friends, and Sancha. Peace.